So today I was watching Judge Simpson's court. Sorry, I'm not on screen right now. I'm at home. Long old day. But anyway, we're watching this here today. We got this guy come in and he's a bit strange from the outset. Now, it's quite something from the get-go. This guy's kind of bizarre, to say the very, very least. But basically, eventually he gets remanded temporarily because there's an accusation made that he threatened a witness in court, like literally while he was in court the other day. So he claims that there's a video that's going to exonerate him. They took a big old long break. I had to go away and sort out some other stuff, and then I had to go back to the office at like midnight to get it because I wanted to bring you guys this video. You won't believe what happens. For some reason, he comes back into court in a wheelchair. Not really sure why that is. And yeah, let's just say things don't go his way. Let me know what you think down below. I'm not going to interrupt this one. Enjoy it. It just kind of never stops being interesting.
Approach on this matter?
No,
On,
my mistake.
okay. State your name.
Lawrence is a family above.
All right, go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right, what are we doing on this case?
Yeah, I have received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that, counsel?
Your Honor, I don't object to the outbreak exam or to defense counsel's request. However, lead counsel is new in the case. He's not aware of something that comprised the public defender of. Earlier this week, this defendant made threats to the witness at preliminary examination.
Yes.
A new charge has
Sir, you need to face me.
a new charge has been authorized against this defendant as a result of his conduct. And as a result of that new charge being authorized, we are requesting remand. We have previously advised the public defender's office.
Judge Rand Washington is in the office.
Your Honor.
Your Honor, this is,
Sir, I will give you an opportunity to address the court, but you're not going to interrupt any. You're not going to interrupt anybody. You're interrupted. Yes.
This exam was held on Tuesday, and after the victim in the case had testified, Mr. Buckner, during a break in the exam, threatened her in the gallery, and we did end up charging him with threatening to injure a witness. And this is a victim that he was not supposed to have contact with, as she was a victim on the FA case. So in that sense, he had violated the bond by contacting her in court and also threatening her with criminal charges, which is why we would be asking for his bond.
Sir, what did you want to tell me?
sir.
Well, Mr. Buckner, I'd advise at this point you don't make any statements.
Mr. Johnson, I need to speak because if I don't speak, if the prosecutor said they want to lock me up in remand, it's up to Judge Simpson. So I have to present my portion of the truth. If I don't, I'm going to jail. Like, I have a family to support. Please, like, I am not guilty. And this is what I,
Well,
okay, okay, on Tuesday, I had a hearing for a situation that I was allegedly accused of, right? During that hearing, it is my belief, so let me just say that, it is my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was on, and I was talking to them, and nothing out of my mouth said, I'm gonna threaten that lady, I'm gonna get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times, 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify who shot you. You need to testify who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family. I got my brothers here. I got people that I support. I don't want nobody getting killed. I died twice in my brother's arms. The next day, I got in an incident with my lady friend, and it went from a domestic violence to a stalking. Ypsilanti police officer Tyson came in to Washington County Jail the very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it, and I didn't do anything wrong. The next day I woke up, I had stalking charge. That was dismissed. That was malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I come to court, and the prosecutors, Judge Rand Washington is the eyewitness. This same prosecutor, while we was in court on camera yesterday, sir, while we was on court on camera, just please hear me, said Mr. Buckner is threatening my witnesses in court. This is what this same prosecutor said. Judge Rand Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening. See, they had already had it out.
Hold, stop. There was a video requested. Does the video show anything?
Yeah, I haven't had a chance to review it. I just got it this morning. But we were informed immediately after the threat occurred. I and she informed our advocate, and then informed us that it had happened. And then she did a police report, and then we authorized the charges.
Your Honor, may I?
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
Your Honor, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Your Honor.
Yeah. Mr. Brown, were you there on that?
I was not, Mr. Michael. First of all, one round deputy. I was not there. Mr. Michael Gaddy was. I'm not sure is this being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things there, and I don't know what there was a request made for video from this courtroom of that day. We got time narrowed down. You need to take your hands out of your pockets. And the request was made. I checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. That was, I think, Byrne provided to the people in this case. They have not had an opportunity to review it.
So as it stands now, these allegations that they have violated nothing's charged.
Well, no, it's basically charged. It's authorized at this point. It's just that it hasn't come through the system yet. Okay, so here's what I'm going to suggest, and it may not like it, but I think maybe this is the way to do it. The video, somebody from your office, Mr. Brown, was handling his exam, correct? Okay.
We just talked to him about it.
He didn't see anything. So what I would do, and I get Mr. Johnson's point, he's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video provided to Mr. Buckner. Mr. Buckner. I don't know what's on the video. I did not view it myself. And then have counsel look at the video. And then I will myself look at it when I get a break to be able to do so. And then make a determination if based upon that, his bond in this case should be revoked. I think that's probably the fairest way that I can potentially do. Yes, sir.
Sir, I appreciate you first and foremost for this opportunity. Can I say this to the court that upon looking at the video, the prosecutor said that I want the whole court to hear it. I physically said that I was going to threaten and get this woman.
Sir, first of all, I don't want you saying anything about what's going to be that new case coming up. I don't want you to say anything. I'm not going to hear it because you're going to end up hurting yourself. What I have said is you will be going into custody. We will then, and I'm not saying even at this point, I'm going to keep you in custody. A video was requested. I'm going to give, the prosecutor's got to look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with your attorney at that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out at least preliminarily.
Mr. Judge Simpson, I'm a very honorable person. I'm asking in all due respect. I'm not a flight risk, sir.
Sir, I'm not saying that you are.
My daughter's in the car. Is there any way that I can call my brother so he can come?
Sir, I'm going to expedite it as best I can to make sure that I can look at it, get you recalled back up and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it, but it affects his case. But the people that can look at it can do that and maybe get in touch with Mr. Johnson. I don't know, but I'm just saying that's the way I'm going to handle it at this juncture. All right?
You don't represent me. Okay. So the guy that represents me is Mr. Gotti. Mr. Gotti is the key factor that you being here.
Okay, look, Mr. Buckner, they'll be able to talk to you back there. But I'll pass the matter. To bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Edward Butler Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. That's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir?
Yes, sir.
And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. You understand that? Mr. Buckner, you can sit down while we go through this.
All right, so I didn't, I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction?
Sir, forgive me for my emotional upbringing. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are.
Miss cameras. So there's no video.
You may want to mute that.
So this is my freedom just snatched from me, and I was understanding that you give me a son where I can't affect the children. You have to charge me. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay? And you said it wrong. Video, but now you tell me what video. That's what I'm not understanding, because the whole basis of my freedom today was Judge Simpson in the video, and that's why I need help. Oh, what charge is this? This is the charge of having April 4th Judge Washington court? Okay. Potential. I understand the potential. I just, from the time, and I apologize ever since, and I'm a little slow right now, so I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge. Ms. Johnson, Ms. Washington, one bond. Yeah. I understand, Judge. I'm sorry, I don't.
Okay, so you understand then the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case. As to the formal reading, you waive any further formal reading of the complaint, stand in. All right. All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
Stay in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I don't want you to tell the judge to adjourn something.
Then I need to be heard on it, and I could find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy bond. Like,
Your Honor,
I need help.
okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that for 20 seconds, not.
All right. So in that matter, preliminary examination will be in person. It would be set for April 22nd, 2025, 9 a.m. That is before Judge. Well, all right. Right, but I think that will be before Judge Washington. All right, and on that case, his bond would continue. All right. So on the other matter, I'll set preliminary examination and I hear what the defendant is saying. What date? PCC. I set it for the 17th. Pardon? Okay, then I'll set it for the 10th. I'll just set it out a week. April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
The allegation here is that my client allegedly had some outbursts that witness examination. I had a chance to look at what was available on the equipment that was done. I'm looking at weaknesses. And strong as the other. Charge with destruction is witness intimidation. That means that he was trying to prevent this witness from coming to court, testifying, trying to change what this witness has. All of it goes to whether that witness would be able to appear in future court. Taking it best, what we've heard in the prosecution said, you've been lying on me. Ms. Evans, my client is not saying he said that, but what the prosecution says that you've been lying, she killed you or something to that effect. She shoots you or kills you. Yeah. Motion is for threatening intimidation is that he has to be doing something to fit this witness. Saying, don't come to court, trying to stop this witness. I think even if we hold her based on her, I don't think the prosecution should be able to take out a case that his intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, testifying truthfully. That's the necessary. Because I do not believe they will be successful in conviction, I'm asking the court set for my client a personal cognizance bond. And here's the reasons why a personal cognizance bond. You have the ability to have no contact. It has a home, it's like 60-80 blocks. It's not having anything to do with money witness lives is separate. He's self-employed, he raises dogs to sustain himself. He suffers from numerous bad living that works already being appraised and he's been shot a lot of times. So he's got health problems that arise with that. Finally, he lives with his autistic needs he has to take care of. He also has a brother who can help him make sure that he returns to all future workmates. But it's a responsible individual. They should. I think the charge is a strong charge. I think it's a charge that even taken in the light most favorable to the prosecution, they will be able to prove that you probably all that stuff.
Thank you.
Thank you, Your Honor. In this case, as in many things, context is key. This exam took place this Tuesday. At that time, the victim testified at exam. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked to go to a bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and his assistant prosecuting attorney. Specifically, this defendant said, "You're lying, the lying fucking bitch, I'm going to get you." This is right after she testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, under people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at exam. The condition of the bond in that case number 5-121. I'm sorry, I may have misread that case number. Was that he had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that he have no contact with the victim in Hudson, have a no-go order as for residential place of employment. And frankly, Your Honor, is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during the court proceeding, immediately after the testimony of the victim, is greatly concerning to people. And to our mind, points to a need to set a significant bond to secure the safety of the public and of the state.
So let me respond, John. Yes, sir. Obviously, very clearly, something different in the prosecution that they described it as an angry outburst. It doesn't rise to any attempt to keep anyone doing anything except that angry outburst. They would make head and try to charge or witness intimidation. It's not that the person already testified, said she was lying, was angry, it was an angry outburst. But we're not going to try to hear it, show the prosecution is that the court takes into consideration the likelihood of conviction. The likelihood of conviction, as the prosecution says very clearly. I think that's the case. And what you have is not angry outburst that's being spun, something based on what they say the context of unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you'd agree.
That's right. Making a line with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging this case, and this is their discretion to give it aside. Context of whether or not they would likely to get a conviction based on that flimsy information they have there. That's not right. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging an entire case. They can't complain to it and say, "Oh, well, we've got a new case based on that."
So there seems to be a misperception because the victim testified at exam that somehow this conduct was not looking to the victim. The victim's testimony would be needed at trial as well. And to make this statement, not only that he accused her of lying, but that he was going to get her. But the same victim has seen this defendant fire a camera and rack the weapons. Clearly, the intent here was to intimidate the witness in question. So, based upon this defendant's conduct, I need a $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to post yes or DPS cover, there will go conditions as to placement of employment residence to the victim. But very clearly, this defendant demonstrated
I don't know that I have a name for the.
The name of the victim, Your Honor, is Amy Hudson. That's A-N-E. The First name,
Say again.
Ameee.
Okay.
Last name Hudson, Hudson.
All right. Anything else, Mr.
No, the way it works is it's on a motion, they respond, and it's supposed to stop.
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm going to order standard conditions, clearly no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy Hudson. You're not to go to either direct or indirect or through third parties. I will also indicate that there's be no mention of Amy Hudson on any social media or any use of any type of social media. You're also not to go to that person's residence or employment, or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate. Should it be that type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
It's possibly going to judge Washington. It's probably the same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, on inside the courtroom. Judge Washington looked right at and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington couldn't help me on this because they got me charged on. They got me charged, Judge. And so this thing, right? For me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom. So.
Okay, and sir, this is the time that I got arrested and you sent me back here. The thing that I was trying to work on you was, I mean, the community of people that was helping me, sir. And I know everything I'm saying, but you've already made a decision. Is that the video inside Judge Washington's courtroom, Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Ray Washington stopped the court immediately and said, no, he's not. He ain't looked at her, he ain't said to her. He's mumbling things to me, trying to get my attention. This is on camera in Ray Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown, Mr. Brown.
Yes.
Thank you. No, I don't, but the conditions available.